Yes, Mr. Sibal.
As my learned friend has with great perspicacity placed the points before your lordships, and I will not repeat them. Whereas let's, in 4, 5, 7 minutes, let me broadly tell your lordships what my submissions are. Whereas your lordships must assume as a given that capital and influence go hand in hand. In fact, under the very concept of a market economy, capital symbolizes power. And it may be in any sector of the economy, as it is in politics. The more capital you have, the more power you have. That's number one. Point number two, the electoral process must be such that it must provide a level playing field to all participants. Fair and free elections, or free and fair elections, is the basic structure of the Constitution. Concept number two.
Just a second. Yes.
Concept number three, the moment you allow the corporate sector to donate, whether with transparency or without transparency, I'll come to that a little later, it is inconsistent with the concept of a corporate sector which is in the business of doing business. You have a memorandum of association which tells you what the objects of the corporation are. The shareholders put in their money to ensure that the corporation functions within the framework of the memorandum of association. Now you give the power through an amendment of this nature to allow shareholders' money to be used inconsistent with the memorandum of the association. It's a very serious issue. And without consultation and without the consent of the shareholder. Under which law, and I ask myself this question, can this ever be allowed? I buy shares in a company. It may be listed, it may not be listed.
But just one caveat, Mr. Sibal, which is that we are not here on the challenge to the legality of a law providing for corporate donations per se. That wider issue is not before us.
I agree.
For the reason that that's what Justice Chagla flagged, Chief Justice Chagla flagged even in 1958. He said there should be no corporate donations, but we are not really dealing with that.
So I'm not on that.
Really into that area at all, because 293 anyway allowed.
I'm not on that. So, I'm on a wider on
what you said in the latter part of your formulation, without the consultation and the approval of the shareholders.
That's the point. Yes. That's the point. That's why I said.
Otherwise, the broader philosophical perspective that allowing corporate donations is really permitting some form of quid pro quo.
No, I'm not on that, because my learned friend has argued that
broad area here, because in that sense, the moment we accepted 293, our society legitimized corporate quid pro quo.
But
there is an element of quid pro quo the moment you have corporate
Exactly. There's no doubt
therefore, about it. That's why a large public limited company who makes a donation doesn't give it for charity.
Exactly.
Or for,
that's why I said capital and influence are Siamese twins.
So we shouldn't really in that
I'm not going there, I'm not. That's why I said that what you're doing in this process is that you are allowing through the electoral bond process to not inform the shareholder as to how his money is going to be spent. Right? And that's a very serious issue because he is invested in the company, not for the purposes of donating to X and Y. That's the third concept. The fourth is even more important. This is nothing to do with the electoral bonds, if you ask me. It is donation to a political party to use the funds as they like. The nomenclature suggests electoral bonds means this is for the purposes of the election. There is nothing in the scheme. There is nothing in the scheme which connects the donation made to the participation in the electoral process. Nothing. It is a means for political parties to be enriched. Why do I say that? I make a donation of 10 crores to a political party through an electoral bond. The political party opens a current account and 10 crores goes into that account. Now that political party can actually give that money to the mainstream media channel and say, you propagate my ideology. Or give a present to somebody. Or do what you want to do with it.
There are no spending requirements.
None, zero. That's the most serious issue. Because you can spend this money any way you like. You can build your offices. You can build your offices all over the country with that money. You can set up a whole internet network throughout the country with that money. You can use advertising campaign for whatever you like with that money. Show your face 20 times a day. And see the nexus. The corporate sector gives money to the political party. The political party and the corporate sector owns a media house. And just look at the nexus. The corporate donor owns the media house. The corporate donor gives it to the political party. The political party uses the media house. No questions asked.
Constitutional argument. Going Ballard on some
No.
personal instances.
I'm not talking of any instance. I'm talking about the scheme. Please do not interfere. I'm talking about the scheme. I'm not talking about any instance. That's the law.
But
But this is, of course, hopefully it is.
Yeah, of course.
I thought we were sitting before 5 judges. I thought I realized by now it is.
it is.
Yeah, thank you. Got to know about it from you.
The Article 14 argument.
Yes. Yes, Manoj. The scheme is wholly arbitrary. It has to be struck down on its terms. It has nothing to do only with elections and how you spend your money in the electoral process. Now, let's kindly have a look at volume 4 and PDF 142. These are FAQs, Manoj, that were asked where the scheme was from the SBI.
142.
140. Yeah, first I'll show you, Manoj, 130, 138, which is a given, Manoj. Actually, I need not even mention this. At 138, the question is, what is the minimum and maximum limit for donation? The minimum amount for donation is 1,000. There is no maximum amount.
138, Mr. Sibal.
Question, Manoj, at 31.
31.
Yeah. Just note it, Manoj. We lots of know, you know about it already.
Yeah, that's okay.
Now come to 142. Question 6. Can a political party use this current account for other operations also? Answer is yes. Next question is 9. Can political party close this current account after the election? The account can be continued for normal banking operations. However, if required, the account can be closed at any time by the political party.
What are you hinting at, Mr.?
I'm sorry?
What are you hinting at?
Manoj,
Can
you
you misuse-
close the account, that's the end of the matter, Manoj.
You did get the money, close the account, but
That's it, and then you spend it the way you want. Well, this is not a scheme for, well, I can understand. Well, quite frankly, I can understand the corporate sector being told that we impose a cess like education cess. You impose a cess on the corporate functioning of companies. With that cess, you have capital, and capital you distribute in accordance with the representation in the Lok Sabha. So everybody has the same amount, and the same money can be used for that. What you are doing now is entirely different. You are saying you give me as much money as you want to give me. That has he's argued, Mullah, that
Your submissions, this is not money for electoral participation, but money for
enriching the
political
party.
party,
Yes.
individual party.
It's just enriching the party.
There are no spending requirements, there's no
whatsoever.
auditing requirement as to how
No
the money is
accountability.
utilized, nothing.
No accountability. Absolutely no accountability.
What's the next point?
The last point, but the
Yes.
fifth point, is that in fact it protects the nature of the scheme protects those who have committed a crime. I'll give you an example. Under the Prevention of Corruption Act, Mullahs, Section 7 of the Prevention of Corruption Act, you give money to a public servant, members of parliament are public servants. Many members of the political party who are in the fray are public servants. Now, as your lordship knows, under Section 7, you can also prosecute a person in anticipation of a favor, not just having granted a favor. So you give a donation, no questions asked. You get a favor. You cannot correlate one with the other. And I can't prosecute you. This is a scheme to protect criminals from being prosecuted. Just read section 7 with me.
Of the PCI.
Prevention of Corruption Act. This is also true under the PMLA. Because a predicate offense has been committed, it results in proceeds of crime. You'll never get to know. Rather than furthering the rule of law, it stymies it. That's the other Article 14 argument. You'll never know who bribed whom, how much was the bribe for, what quid pro was there. You'll never get to know. That there is quid pro quo, Malaz, is in my first submission. That capital and influence go together. Malaz, nobody can doubt that proposition, Malaz. So in effect, through this scheme, you are trying to protect those people. Where the source of the money is, my learned friend has argued, I don't want to repeat anything that he has said. And let's see what is the scheme. If it's less than 2,000 rupees, it's cash. If it's more than 20,000 rupees, the name of the donor has to be given. And if it is electoral bonds, nothing. That's the 3 layers of the scheme. So while the donor's name will be given if it's more than 20,000 rupees, right? And so ordinary, ultimately, let's put it this way. This constitution is for the citizens of this country to participate in the election. The corporate sector is not a voter. The citizen is the voter. The citizen is entitled to contribute. If he gives more than 20,000 rupees, his name will be there. But the corporate sector, who is not a citizen, can donate 10 crores, 100 crores. His name will not be there. What's the rationale for that? I, as a citizen's name, it will have to be disclosed. So, is the corporate sector being granted a privilege over a citizen of this country? That privilege of anonymity? How is he more privileged than a citizen who is at the heart of the Constitution of India? How is he being given a preferential treatment? Why? Because you want to enrich yourself through this scheme. And enrich yourself because you're in power. Whereas the opposition may be in power in a state. They will also enrich themselves. This is not political. Because all business will actually be attracted towards this scheme because this is one way of getting access. I just pardon me, Malas, for saying so from personal experience. If people donate, Malas, we know who is donated. He will give me a call and say, sir, I want to come over. I will hear him. But if I don't know his name who is donated, Malas, I won't listen. How many calls will I answer? So you get access, straight away you get access. And all this anonymity that we're talking about is really not anonymous. Because the person who donates will go and tell him orally that I gave you such and such money. This is the amount I gave you, 100 crores. Only he will know that he gave.
The anonymity would exist only if it was truly fungible.
That's right.
In which case, if it's truly fungible, like a demat account, in which case, you give it to, say, the election
Then it's
commission.
anonymity.
and then it is,
Correct.
then it becomes anonymous.
That's right. Now it is not. In fact, it is not anonymous if you ask me. That's my submission. Because I have given 100 crores, I know that I bought a bond. My learned friend, Mr. Mr. Shant Bhushan said, no, he give it to a third person, doesn't matter. But who is interested in that bond? The person who I bought the bond. So I will go and tell whoever I want to tell that I gave you. So he doesn't have to go to the State Bank of India. Let's talk practical politics. He doesn't have to go to the State Bank of India to find out. Nor does the State Bank of India have to disclose it. The person who gave it will disclose it. Because he knows why he gave it. So what is anonymous about this? This is protecting the rich.
There is another thing.
Yeah.
The issue which we were just discussing, on which perhaps the learned attorney may give us an answer, but since Mr. Sibal is on his leg, we will just put it to him, Mr. Attorney, and Mr. Solicitor, you can also, in your turn, you can answer. Suppose A purchases the bond.
Yes.
A purchases bonds worth X amount, 100 crores.
Yes.
A is only the person who's been put up to purchase the bond because
That's
that A has a KYC, etc.
Yes.
A has to only physically hand over the bond to B,
Yes.
right? Who's in, or B gives it to C, who will in turn give it to a political party.
Correct.
Now, B, there is no control over the transaction between A and B.
Yes.
So B can trade on that bond for cash or for
Yeah.
whatever other consideration.
Yes.
B acquires that bond.
Yes.
B hands it over to a political party.
Yes.
Or B gives it to C and C hands it over to a political party.
Yes.
The person who has satisfied the requirement of the transaction being through the normal banking channels is A, the purchaser, the ostensible purchaser of the bond.
Correct.
But this does not obviate the fact that the people who are really
Behind it. Yes.
that they have used authorized banking channels.
Yes.
All that they have to do is that the
Get somebody's
it
KYC.
says trading is prohibited,
Yeah.
but there's no way you can prohibit trading in the
Absolutely.
bond.
Absolutely.
he doesn't have to buy the bond from
No, he
A
doesn't.
through official banking
no,
channels
no.
because there's no record of any transactions in the bond. It just goes from hand to hand.
That's right.
Because of the curtain, then you cannot be any questions with regard to quid pro quo.
That's right. And then, Maharaj, ultimately, the person who is actually invested in it is the person who will tell the political party. Who's the holder ultimately?
No. In this case, probably they'll know who's the
Could be
purchaser.
B or C.
They'll know the purchaser, but the actual purchaser is A.
Exactly.
Whereas in the KYC, etc., A is the one who's.
That's right. Absolutely right. So, Maharaj, this is, it perpetuates.
Also, B may be an aggregator of the bonds.
That also.
By having 10 different people subscribe to 100 different people subscribe to a bonds worth 1 crore each.
That's right. Well, there the human, at least the Indian human mind is ingenious in these matters. We control the economy of the world in many ways. And the RBI raised these concerns repeatedly.
Thank you.
This is we must show that. Now look at question C, frequently asked questions FAQ, page 138. Question number 36.
128.
138, question 36. My lord has that? Who is the bona fide owner of the electoral bond? Okay. PDF 138. Who is the electoral owner of that? Who is the bona fide owner of that bond? Electoral bonds are bearer banking instruments. It's exactly what my lord the Chief Justice said. And the holder of electoral bonds is the bona fide owner of the same. Nothing can be more anonymous than this. All that you need is the KYC, that's it. And then see 17 at page 31. Page 131, PDF 131, question 17. Can electoral bonds be purchased multiple times by the same applicant? Yes. Yes, every application will be treated as fresh request for electoral bonds purchased, and every time fresh KYC documents will be given. So you'll have bond brokers, you'll have in-betweens, you'll have all kinds of people participating in this. So it's not just a question of transparency, Malas. It's much wider than that. Last of all, Malas, if I do not know these facts, if I don't get to know the name of the donor, I don't get to know the transaction, I don't get to know the possible direct or indirect quid pro quo, I can't participate in democracy. It is also a matter of participation in democracy. I will then be sued for defamation that you made this allegation without the facts. But how will you get to know? How will I get to know the facts if you hide the facts through an electoral scheme like this? I can't raise questions in Parliament. I can't raise questions outside Parliament. Because the scheme, Malas, has no definite objective. If it were a definite objective of funding through the corporate sector, the process of election without funding a political party, I can understand. You can have electoral bonds to fund the election process. But what you're doing here is you're funding a party. It's different. The object is different. So you call it electoral bonds, but these are not electoral bonds. And the limit of expenditure has nothing to do with it. Well, it's 123(6) of the Constitution, of the Representation of People's Act, talks of expenses. Corruption, an act of corruption beyond 95 lakhs now. So the larger issue that your lordships will have to consider that this is no part of participatory democracy at all. Every scheme must have a legitimate object. What's the legitimate object here? Which is constitutional. The scheme must be such, it must be proportionate to the object sought to be achieved. And the underlying principle under the Constitution is free and fair election, which is a basic feature of the Constitution. How are you serving these three purposes, Malas? You are serving none of these three. No legitimate object because it is not limited to the elections. No proportionality because it's unlimited. And no free and fair elections because my learned friend has shown to your lordships how heavily it is loaded towards the party in power. So you are creating a non-level playing field through the electoral bonds. And that's violative of 324. Now, Malas, historically, as your lordship knows, Malas, in 1969, through legislation, we had, Malas, prohibited corporate donations altogether. And then 1985, Malad, through an amendment, we said, okay, the corporate sector can donate, but only to the extent of 5% of the average earnings in the last 3 years, 3 financial years.
5% or 7.5%?
I'm sorry? Initial 5%. Whereas 85 was 5%. Then through an amendment, it was 2013 Act, it was changed to 7.5.
2000?
13. The Companies Act. Well, actually, I've put it all in the written submissions, but because my learned colleagues are waiting for me to end, so I'm not wanting to take their time. Well, your lordships have said that do it, be as short as possible. But whatever I have said to your lordships, Malad, are the propositions that emerge from the scheme itself.
Mr. Sibal's submissions are in which volume?
Volume 1.
Again, volume 1, right?
Yes,
Yes,
volume 1. All the submissions.
All the
are in
submissions
volume
are.
1.
Yes, we got
And it's page 48.
48.
PDF 48. And if you just, I'll take few minutes, Malad, then I'll be done. Because my learned friends, I want to give them time to. The first, Malad, few pages are just the scheme itself, the electoral bond scheme itself, goes up to PDF page 63. My lords have that. It's just the elements of the electoral bond scheme which have already been well explained to your lordships. So I will not trouble your lordships with that. That's been explained. But you come to 63, then Malad, I deal with the issue of free and fair elections under the Constitution. And I say it's the basic feature of the Constitution. And it's now recognized that para 15, Malad, I say, as will be developed below, any nature of funding that is opaque and that seeks to hide the source of funding is contrary to the spirit of free and fair elections, which is part of the basic structure. That's the transparency argument, plus the free and fair in the context of which, in the context of my submissions before your lordships now. Then election is a vehicle of representative democracy. I've given judgments, Malad, page 66, and then para 17 at 66. Is the constitutional mandate of free and fair elections under the principle of universal adult franchise is the central pillar of our democratic culture. Under our political system, elected representatives do not have any political legitimacy independent of the will of the people and must discharge their duties in public trust. But it must never be forgotten that this constitution is citizen-centric. It is for the citizens to decide to donate. If you want corporate funding, then that corporate funding must be for the electoral process. It must not be for political parties. Otherwise, it will not be free and fair election. Then, therefore, Maras, you must interpret superintendent's direction and control of the conduct of elections in that context. That's set out at page 67, end of paragraph 19. Then I differentiate between freedom and fairness, which is para 20. I won't, Maras, trouble your lordships with the language. And para 24, I say economic power at page 68. Economic power presents a grave risk to any level playing field between individual citizens and groups and can give some voices a disproportionate say in deciding the agenda of the political parties and hence the laws and policies that will govern the entire country. In pluralistic democracies like India, practices must emerge that preserve the equal voice of all citizens and that ensure that the special needs of all groups are heard. But if the voice of the corporate sector drowns the voices of citizens, that's a very dangerous trend in democracy. Then, Justice Bhagwati's judgment in Kamalnath Gupta's case, let's leave that out. I think that's one extreme position, which I don't want to argue. And then, then this is important. Kindly see, para 36 at page 72. Reiterating my learned friend's submission that it's the voters' right to know. That's fine. And this whole concept of black money, I mean, I don't understand the cash that is given below 2,000 can be black money. The 20,000 rupees has to be disclosed. That also can be black money. Because you can say cash in hand, 20,000 rupees. And the electoral bond can also be black money. And over and above that, there is black money. Because there is cash that doesn't go into electoral bonds. So what is this black money issue about? The kind of extravaganzas that we see, is what? Is it white money? So this has nothing to do with black money. This is the case of the government. That black money was used earlier, no doubt. Black money is used today, no doubt. There is more cash in the market than it was in 2014 or 2019. That's government's own statistics. So black money is a bogey. And all three elements can be part of black money. That can't be an argument. So dealt with. And then, so the three issues, I have raised at page PDF 75, whether corporate donations should be allowed at all, but that's not a question that your lordships has to answer. If yes, what kinds of companies should be allowed to make such donations? If corporate donations are allowed, what cap of net profits should be set? And who is the appropriate body within the corporation to authorize such donations? That's if you agree to all what the other side says. If you agree to what the government says, then these questions will arise. But that's subject to my submissions that I've made to your laws. The shareholder argument, I've placed there, paragraph 43, the objects of the company and all that, which I've already commented upon. Then I've given the history. Then 2013, my lord asked the question, the cap of 7.5, that's at para 47. And actually, there's a wonderful report of Justice Shah, I think at the Law Commission, which actually sets out the practices in all the countries, UK, US, Japan, Philippines, Australia, and Germany. And in all those countries, there is no question of any opacity. Most countries do not allow corporate donations at all. But where they do allow, there is no opacity.